Before we begin this presentation, a brief foreword is in order. While the corresponding paper might not be regarded as a transcript of this presentation, one could regard it as a useful supplement. This is hardly unexpected, as both assignments are essentially different mediums covering the same topic. In this presentation, we will try to include details that, while not significantly departing from the scope of the paper, serve the goal of avoiding complete redundancy. Our work in this presentation can be summarized into three broad steps. Firstly, we will investigate the seizure problem. Then, we will inquire into the analogous issue in Europe. And finally, we will provide an ethical analysis of the problem. To begin then, the seizure puzzle. Imagine the police seize a suspect's computer. Eventually, they return the seized device, but before doing so, they create a copy of all the data on the device. Crucially, they do not open that copy, but maintain it on standby pending an authorization to peek. Now imagine that the FBI were suspicious of a person's internet activity. They install email spyware to secretly copy the suspect's private email correspondences. Again, they do so under the premise that they are merely being proactive. That is to say, they have not looked at them, they are merely retaining them until they obtain the proper authorization to do so. In both of these scenarios, the police have a convenient way of maintaining unrestricted custody of a version of an individual's private data via their created copy. Our clever police officer asserts that we haven't really seized anything. Just ask the owner, who claims to have had their possession withheld from them, to produce that object in question. The seizure problem is precisely the question of whether the officer's reason is valid in a legal context. In both of the scenarios presented in the previous slides, the government depends on their copying not constituting a Fourth Amendment seizure. Generally, we can phrase the seizure problem by asking whether the copying of computer data is tantamount to a Fourth Amendment seizure. Incidentally, this question has major ramifications on the practice of modern computer forensics that typically require specialists to copy a suspect's data onto their own lab machines as a preliminary step to their forensic methodology. Legal precedents surrounding the seizure problem are decidedly mixed. In order to clarify that vague assertion, we will examine a few cases which illustrate how the seizure problem originated. We will only examine about 4 cases, each of which suggest a particular stance on the problem. In the case of Bills versus Aseltine, proceeding on exigent cause, Sergeant Aseltine conducted a search of plaintiff Bill's abode. Upon doing so, he came across a suspicious radio equipment and, acting on his suspicions, copied down the serial information on that radio. Afterwards, he compared the number against a police database and found that the equipment were indeed stolen. In court, Bill claimed that Aseltine violated his Fourth Amendment right against unlawful seizure by the unwarranted copying of the serial number. The Supreme Court, however, ruled in favor of Aseltine, citing that the mere recording of the serial numbers did not constitute a seizure. as it did not meaningfully interfere with the respondent's possessory interest in either the serial numbers or equipment. We are already familiar with the case of US versus Gorshkov. In this case, FBI agents, based on their suspicions, elected to copy a file held on a remote server and maintain it on standby until a search warrant could be obtained. Crucially, the FBI proactively secured any evidence which could serve their case on the technicality that they have abstained from unwarrantedly peeking its contents. The question of seizure thus alone disputed, the verdict reached by the presiding judge was that the copying of the file did not constitute a seizure, because the original remained both preserved and available to the intended parties. As a result, the copying had absolutely no impact on the defendant's possessory rights. The verdict reached in the case of US versus Jefferson provides our first instance of a ruling that recognizes copying as an act of Fourth Amendment seizure. In this case, FBI agents conducted a warranted search of the home of a congressman suspected of both fraud and political corruption. During their search, agents captured high-resolution images of incriminating documents. However, these documents were arguably outside the scope of the warrant. Despite the obvious search violation, what is interesting is the court's ruling that the Fourth Amendment's privacy interest extends not just to the paper on which the information is written, but also to the information itself. In New York versus Berger, attorney Ralph Berger was found guilty of conspiracy to bribe a public official. During his trial, the Supreme Court invalidated a New York statute governing bugging precedents on the grounds that the officer is given a roving commission to seize any and all conversations by virtue of the statute's failure to describe with peculiarity the conversation sought. Interestingly, the Supreme Court verdict recognizes the act of recording or copying the conversation as a Fourth Amendment seizure. Overall, we are now clear on why decidedly mixed is a fair assessment of the legal precedents surrounding the seizure problem. However, how do we reconcile the conflicting views regarding the seizure problem? Enter Kerr. Kerr is a reputed jurist and professor of law, and his solution to the seizure problem can be summarized briefly as, it depends. Kerr's test of whether the act of copying is tantamount to a Fourth Amendment seizure or not depends on whether the copying occurs pre-observation or post-observation. Kerr's astute test makes short work of these cases and, interestingly, disagrees with only one ruling, that is, the verdict of US versus Gorshkov, wherein the copying occurred pre-observation and thus, by his test, ought to have been a positive Fourth Amendment seizure, contrary to the court's ruling in that instance. The seizure puzzle is a profound issue, so much so that we simply do not have enough time to cover everything that can be said on it. For more information, see my paper. Because we are pressed for time, I will briefly pass through the remaining sections, trying to present the salient points of each as quickly as I can. Seizure around the globe. Does the analogous problem exist in Europe? The answer to that question is not necessarily. In France, the Criminal Procedure Code recognizes any act of copying or recording data as an act of seizure. In England, the Police Criminal and Evidence Act, along with the Police Criminal and Justice Act, collectively empower law enforcement officers with the ability to copy or record any computer data as a means to establish probable cause. To appreciate that, If the case of US versus Jefferson was held in a UK court, the court would not have ruled in favor of Jefferson, unlike in the US. Ethical punditry. We will begin by introducing utilitarianism very naively. The figure on the right is Jeremy Bentham, who was a philosopher and jurist from the 18th century. He is widely regarded as the father of utilitarianism, which is an ethical school of thought that maintains that all social morals in government legislation should aim for procuring the greatest happiness for the greatest number of people. In short, they wish to optimize for globally maximum utility or satisfaction. In line with the original goals of utilitarianism, we ask ourselves, what utility hangs in the balance of the seizure problem? On one hand, by enabling the police to record or copy data, we empower them to secure the welfare of society. On the other hand, there is something strikingly Orwellian in the notion that government powers can maintain copies of your private information without any recourse or regulation. Kerr's solution that copying is never always nor neither never seizure has the benefit of compromising between these two extremes, perhaps achieving an overall optimal average utility. As we are already a bit over time, I won't mince words with the ending, and I hope you enjoyed this presentation.